Hey gun people, for the ones that came back for this grueling coverage of boring law that Rick's just going to sit there and run his mouth and talk about stupid shit. I don't have time for this, so I'll make a comment and cry. All right, whatever. For the people that want to go through this, we'll go through it, and I'll try to share some of my experience and circumstance. Officers will sometimes knock and talk, but because the courts view this more intrusive, there are some additional restrictions. We cover the restrictions in the article Knock and Talk in the spring edition. So I'm not even sure what these restrictions are. I'm kind of curious. Maybe I should go look that up, but we'll keep going with this page. Okay, principles of contacts. A police suspect encounter or contact, those will be used, consensual encounter, non-custodial contact, all those words is what that means. Non-custodial means you're not in custody. Okay, a police suspect encounter will be deemed a contact if a reasonable person is in the suspect's position would have felt free to decline the officer's request or otherwise terminate the encounter. This is really critical, and this is why I say not only don't talk to the cops, but walk away. Walk away. Get in your car and leave. Terminate the contact. Force the officer to say, hey, you can't leave. Okay, boom. Now I'm detained. Now that I'm detained, we know the rules. You obviously have reason to suspect me of a crime and that I'm engaged in criminal activity. And now you can ask questions. Why am I detained? Why do you suspect me of a crime? What is the crime? What led you to believe that I was involved in this crime? And when the officer doesn't want to answer these, and then later in court comes up with a whole bunch of answers, he will look bad and you will look like, hey, I tried to ask this. I gave the officer a chance to articulate his probable cause for reasonable position. And the officer will say, I don't have to justify that to the officer. Well, you don't have to, but it doesn't look real good when you don't. If you got, it's like, I don't have to show you the radar that I got you for speeding 100, but if I show it to you, you really don't have any arguments. So why wouldn't I show you? Unless I didn't have it on radar, unless I was lying. Now you leave me all these defenses to use against you. So let's see. To put it another way, a reasonable person would feel free to disregard the police and go about his business. The encounter is consensual. Just like when you open the door and you don't shut the door. Just like when you call 911 and you stay on the phone. Just like if a police officer calls you in your house, which I can do absolutely legally, if I think you're up to no good and I know you're in a house, and we've done this before in a certain way, but if I think you're up to no good and I know you're in a house and I've got a number, I can call that house and say, hey man, I'm the police and I know you're drilling drugs in there and I'd like to come over and talk to you. Will you talk to me? Man, fuck you. You're not the cops. If I don't give a fuck, you come over here, I'll kick your ass. Okay, I'll be there in a second. And I can go knock on the door. And now I was kind of somewhat invited. Now, that's not really a good excuse. The way we've used it before is if we're surrounding a house and we want them to come running out, instead of going inside the house because it's easier, we'll get a couple guys in the back, a couple guys on front, and then make a call inside, conceal our voice. Yo, man, the cops are coming. You better get out of there, and hang up. And sure as shit, someone with a warrant or on parole will come bailing out of the front or rear door, and we'll snag them. Well, Rick, you don't have any reason. Yeah, I do have reason. We made the call. We told him that the cops were coming. His furtive and flight movement is a consciousness of guilt. And when he came out of the house that way, we were watching it, and we had reason to believe that criminal activity was going on in there, so we had enough to detain him. As a matter of fact, when he saw us, he said, shit, the cops, and continued to run. So, and when he was running, I thought I saw a bulge to where he was either carrying drugs and or a weapon. All right. Rick, you're a bootleg. Shut up, you freaking crybabies. Let's see. So I don't know how I got to that. Later in this article, we'll discuss a relevant, determined, reasonable, innocent person. Ooh, they threw in innocent. See, this is why when you read things, you kind of get. Because most cops that don't know and were just told, all I need is a reasonable person. Well, the courts have just said reasonable, innocent. It's in quotations. Person. One of the most important things to remember about the fictitious, reasonable suspect is that he is innocent of the crime under investigation. And the reason behind that is because an innocent person will think different than a guilty person. They will act different. Rick, you can't do that because that's a hunch and it's against... Oh, that's because you're an idiot and you're just repeating shit and you've never done it. So, all right, an innocent of investigation. Said the Third Circuit, what a guilty suspect would feel and how he would react are irrelevant to our analysis because the reasonable person test presupposes that a innocent person, 12. So if you go down here to 12, you can go see the case where they ruled that U.S. v. Kim, Third Circuit. So if you want to read the case law, that's what that little 12 is. This is significant because a person who was guilty of a crime under investigation might reasonably view the officer's words and actions as more ominous. I think that's the right word. I guess it's ominously. Ominously. Okay? Yeah, all right, whatever. I screwed up. You guys can have fun with that. Rick can't even read. Shut up, freaking idiots. Ominously, that an innocent person and might erroneously conclude that any perceived restriction of his movement was an indication that he had been detained. So, the courts have thrown in innocent if you are innocent of the crime. So if you're guilty of something, your actions will be looked at differently. That's important. Okay, should versus must. Should and must, usually in the law, must and shall is the word that means you have no choice. When the courts say to law enforcement, you must do something or you shall do something, that means you don't have discretion. It's ordered by the court. When it says you should, could, maybe, if and buts and coconuts, then you don't have to. You can, but you don't have to. So I'm not sure what they're going to get on this, should or must. The test whether a reasonable person would have believed he must stay or was otherwise required to cooperate with the officers. A detention does not result merely because a reasonable person would have believed that he should do so. Again, state of mind, totality of circumstances. Just because I'm dealing with some dumbass citizen that thinks cooperating with law enforcement is a good thing and makes them a good person does not matter if they think they should do that. Okay? It's not a detention. It's an encounter. So, words have meanings, actions, behaviors, beliefs, what you thought, what a reasonable, innocent person would have thought. Has the Court of Appeal observed, cooperative citizens may ordinarily feel they should respond when approached by an officer on the street, but this does not by itself mean that they do not have a right to leave if they so desire. This may have held true 15 or 20 years ago when cops weren't out there shooting, killing, beating, and just being totally tyrannical. That may be hold true. Nowadays, any citizen who is stupid enough to believe that the cops are your friends and you should cooperate and help them, well, then you deserve what you get. Don't come crying to me when you're sitting in a jail cell. I should have listened to Rick. He was right. I thought he was an idiot. Well, that's tough shit. All right. Have a right to leave. For example, in this court, the court ruled the innocent person who saw two officers approaching him would not have felt restrained, but would only concluded that the officers wanted to talk to him. Okay. There would be times when a cop approached me. If I'm standing around as a witness at a car accident and I'm the only guy there and the guy's walking around and the cop starts walking over to me, he's probably going to ask me, hey man, did you see anything? Why are you here? And if I'm a good citizen, a good dumb citizen, I'm going to hang around and talk to him and try and help him. Because I'm going to think like a dumb citizen thinks, that he won't for some reason see me as a pesky citizen and just a means for him to get a stat or whatever. And if he can find a way to arrest me, he will. And even if he doesn't arrest me, he's going to put down my name and contact information, give it to the DA, and now I'm going to have to take time off work out of my day because I'm a witness and he's got my information and I was a dumb citizen that stood around and helped, and now I'm going to get subpoenaed to court. And if that court gets continued 3 or 4 or 5 times and I have to take days off of work 3 or 4 or 5 times, tough shit. That's my money. That's my own damn fault for standing around thinking government's my friend and I want to help. Don't freaking talk to government, people. Objective versus subjective circumstances. Okay, subjective usually means it's what I think. Objective is what more factual. So let's see. In applying the free to terminate test, and that's the court rule, this is in quotes, so a court has ruled the free to terminate. Suspects, victims, citizens are free to terminate. That means they are not being held against their will. That means they can walk away. That means they can shut the door. That means they can drive away. That means they can not say anything. That's the free to terminate or free to terminate language that the courts are using for this. The free to terminate test, and they actually have a test for it, the courts will consider only the circumstances that the suspect may have seen or heard, much like when officers determine reasonable suspicion and probable cause. When a cop acts, he has to be able to articulate why he did what he did with what he knew when he did it, not what he finds out later. Thus, the officer's thoughts, beliefs, suspicions, and plans are irrelevant. Didn't I cover that earlier? Didn't I say if I wanted to be a racist and I wanted to stop a black person because I'm a racist for no other reason, but because I'm a racist and I want to stop them, it doesn't matter. Break this United States, we have a constitution, you can't do that. Yeah, you're a freaking idiot. Okay, I'm telling you. The courts just said it again right here. The officer's thoughts, beliefs, suspicions, or plans are irrelevant unless they were somehow communicated to the suspect. With this sentence, if I'm being a racist and I want to stop a black person, as long as I don't say it, I'm okay. But if I say, yo, brother, you're a black man in my neighborhood and I want to stop you because I don't trust black people, now I've communicated it, now we're going to have a problem. But if I think it, I'm legal. And vice versa. If a black man doesn't like a white woman because he was dumped by one, and he says, you're a white woman, and I want to stop you because I don't like a white woman, he's articulated and communicated that, it may be a problem now. But if he just thinks it and believes it, he is 100% legal. I mean, when I tell people this, they want to get mad at me and say, Rick, you're just making this shit up. That's not true. Look, people, I'm trying to educate you, and you can either want to learn and or you can just argue and think you're right and want to be right and tell me how wrong I am. I've been doing this for a while, so I'm right a lot more than I'm wrong. Doesn't mean I don't make a mistake, but I'm telling you. All right. Officers' thoughts are irrelevant unless for example, an encounter will not be deemed a detention merely because the suspect testified based on his prior experiences with officers. He thought he would be arrested if he did not comply. See, this is where the pesky citizen thinks he knows the law, and he hung around thinking if he didn't comply, he would be arrested, when in fact he was free to leave. Therefore, he gave the officers more information because his dumb ass hung around because he thought he was right and he was smart. And he didn't know what the hell he was doing, and he hung around, and now he's kind of crying. I wish I would have watched Rick's videos because I wouldn't have done that bit. Well, too bad. Just write me a postcard in jail. Totality of circumstances, obviously, I've said this phrase a lot. The court uses this a lot because it matters. What I smell, what I heard, what my beliefs, what my prior training was, what happened right before the incident, what came over the radio, how many officers there, whether it's dark, daylight. There's 1,000 things that come into totality of circumstances, and you better be able to articulate all that on the fly when you do something, especially when you do something that results in somebody dying, or you're taking away their freedom, or you tried to take away their freedom and they end up killing someone else or hurt someone else because of your actions. You better be able to articulate what the hell was going on in the totality of circumstances. All right, in applying the free to terminate test, the courts will consider totality of circumstances, although there are some actions that will automatically convert an encounter to seizure. What can some of those be? The court said commands and handcuffing. Okay, so if I put handcuffs on you and I say you're free to leave, the courts are going to go, you're full of shit. That action converted the contact to a detention. If I command you, don't leave, you are no longer free to leave. That is not a consensual encounter anymore. If I say, hey, you can leave, but I wouldn't if I were you. Oh, now The courts have to figure out totality of circumstances. What happened before? What was said before? What was in the state of the mind? Would a reasonable person take that as a threat? Would a reasonable person be coerced? If you said that to me, I'd be like, either I'm detained or I'm not. I'm freaking leaving. So, it all depends, which I use that phrase a lot. It depends on what the action believed, what the officer, the suspect believed, what the suspect heard, what was in his mind. What was in his mind? Was it reasonable? Is it reasonable to say, man, I saw a cop episode, and when the cop said was free to go, and then the guy left, they beat the hell out of him. So when he told me I was free to go, I thought I was going to get beat up, so I stayed. Well, you're a dummy, because that's not reasonable. Just because you saw it on cops one time doesn't mean it all the time. All right, let's see here. Commands and handcuffing automatically deterrent. That's obvious. In most cases, it takes a collective show of authority. Okay, this is in quotes. So the courts are saying collective show of authority. What isn't a collective show of authority? Could it be number of officers? Could it be blocking your path? Could it be a car parked in front of you in one direction, a car parked behind you in another direction? Is that a collective show of authority? Is still cops showing up running code 3 with lights and siren? Is that a collective throw? I think all those things do matter, but you're going to have to be able to articulate that's what caused you to do what you did. If you just said, no, man, I was just afraid and I ran. Well, that's not going to do it. So let's see. Collective show of authority. California Supreme Court explained this test, coercive effect of police conduct. Okay, coercive effect of police conduct. That's what I was talking about earlier. If you have 5 people in an interview room, 1 guy, that's kind of coercive. Even though the 5 cops are eating donuts and we're all drinking and we're laughing, 5 cops with 1 guy in a room, I think the courts are going to rule coercive no matter how friendly you were or what you were doing. Okay? Hell, 2 cops in a room with 1 cop with his hand on his gun, because there was a case where the courts ruled it wasn't a detention or the guy was probably free to leave until the cop sat on the table, blocking his path, invading his space, and putting his hand on his gun. And they converted that to detention. So actions have meanings, and if you don't know that as a cop, you can inadvertently make you're free to leave, because a lot of cops get a lot of great information by telling people they're free to leave. And most of the times when we call in people that we want to arrest, and we go, yo, man, you're not on arrest, but we kind of want to talk to you to clear you. So we don't, can you come down the stage, talk to us? We just want to sit in an interview room and talk to you. Okay, that's cool. As long as I'm not on arrest. No, dude, I can give you a ride. You can come by yourself. I can follow you. You're free to leave, man. You're free to leave now and you're free to leave then. I would just like to sit down and talk to you. You voluntarily come and sit in a room. Man, great confessions and great information is seized that way every day, all day. Because people come in there and talk and they think they're smart and they think they're free to leave and they try to outsmart us. And they end up digging a hole. They end up getting themselves caught in a lie. They say something they should have. They change what they said. And now they're just the whole time they talk to us, we're just developing more and more reasonable suspicion and or probable cause. And then right when they get up to leave, the guy goes, you know what? Fuck you guys. I'm leaving. And we go, sorry. We told you were free to leave, and you were. But as of right now, you're under arrest for attempted homicide, attempted murder, whatever. And we hook them up. You're like, dude, man, you can't do that. You told me I was free to leave. You were free to leave. You were free to leave the whole time. Yeah, but as soon as I said I was leaving, you arrested me. That's right. At that point, you were not free to leave. But you didn't know that. We told you were free to leave, and all you knew was you were free to leave. And as long as we didn't lock the door, shut the door, and barricade you, you were free to leave. Now, if I have 2 cops in uniform standing at the door blocking his path while I'm talking to you, telling you you're free to leave, we might have issues. Small things matters. And cops who don't deal with this and never have been involved in this and never had to defend it in court will tell you, I know the law. Yeah, as long as you don't put them in handcuffs, they're not detained. You're freaking wrong. You're a dumbass. And there's a lot of cops that believe that. As long as I don't handcuff them, they're free to leave. I told them they were free to leave. As long as I handcuff them, I'm good. No, you're not. Okay? Let's see here. Compared to Miranda, do not confuse free to terminate tests with the tests utilized for Miranda. Now, we have a free to terminate test for Miranda warnings, and we have a free to terminate test for detentions and contacts. And they're different. Rick, cops are stupid, and anybody you could graduate. I'm telling you, when you dig into the law and you know the law and you start dealing with the law, It's not as simple as people want to make it out to be. I don't think it's that complicated. If you do it every day like anything, it becomes easy and you figure out the rules and until they change it. But the rules change every day. Every time there's a court hearing, every time there's a new case, every time there's outcry, every time there's a BLM riot, things change and the courts makes new rulings. And to stay up with all that usually takes work, which is why this magazine is such a great tool, because they keep you up to date with the current changes and how the courts are changing. What you could do last month, you may not be able to do this month. And I've been caught up in that before. I did something by the law, knowing it was by the law, and I know I was correct, and I was like, shit. And a DA goes, oh man, last month they had a court ruling that did that, so shit, we can't use this. I'm like, holy shit, I didn't hear about that one. So shit happens. All right. Let's see. Miranda for in custody. Although both tests attempt to gauge the coercive pressures that existed during the police suspect encounter, suspects will be deemed in custody for Miranda purposes only if they reasonably believe they were under an arrest. Remember, for Miranda to work, you need custody and interrogation. I don't need Miranda if I just have you in custody. I don't need Miranda if I just ask you questions and you're free to leave. I only need Miranda when there's the two-pronged test of custody and interrogation. That's when I need Miranda. A lot of cops don't know that. But a lot of cops think, oh man, if I got arrested, I got to read your rights. Well, no, you don't. I only got to read your rights if I'm going to ask you questions. If I'm not going to ask you questions, I don't need to read your damn rights. I can arrest you all day long and never read your rights, as long as I don't ask you questions. Again, there's a difference between saying you're a police officer and knowing what you can and can't do in accordance with the law. Let's see. In custody, thus detainees may be in custody for the Fourth Amendment purposes, even though they knew they had not been arrested. Okay. Compare street reality. It must be acknowledged that many of the things that officers may say and do without converting a contact into a detention would probably send a message that the suspect was not free to terminate the encounter. Well, I think as soon as the cops send the message that they're not free to terminate, they convert it into a detention. That's what we're talking about. In fact, one court described the idea that a contacted suspect would ever feel perfectly free to walk away has the greatest legal fiction of the late 20th century. And I agree with this court. Anybody who thinks they're free to walk away when they're contacted by police are probably a fool. Because cops don't walk around and talk to people. Cops are not out there being your friends. Cops do not care what you think, and most cops don't want to talk to you and don't want to be your friend. They want to come, get their stats, collect their retirement and their pay, and have as little contact with you pesky citizens as possible. And I was in that boat when I went 8 code. I hated it when people wanted to walk up to me when I'm trying to eat, and I'm going all these calls, and I finally get 30 minutes to sit down and eat uninterrupted, and I have people walking up. Hey, how you doing? I just want to tell you, man, you guys are doing a great job. Want to shake your hand, blah, blah. Okay, great. Thanks a lot. Thanks a lot. But Rick, they were trying. I don't care what they were trying to do. I'm just telling you from a personal level, I'm trying to eat. I'm trying to have some peace. I don't care what you pesky citizens want to tell me and make friends with me, etc. That's not the way policing is nowadays. Okay, especially in the job I was in where I was out there handling with bad guys, dealing with bad guys. I was not out there for community relations, and I wasn't out there to make good impressions with the public and all that shit. I was out there to get bad guys off the streets. So, and most cops just don't want to be bothered when they're eating. You may think you're being nice. You may think you're going over there doing a good thing. Most cops don't want to deal with it. You're interrupting them. It never ends. It's never just, hey, I want to tell you I appreciate what you're doing. Enjoy your lunch, and they walk away. That never happens. It always starts out as, I just want to tell you you're doing a great job. And then he goes, hey, man, I got a question. Okay, I got a ticket, or my son was contacted, and it always turns into a question. And now I got to stop and I got to listen to your bullshit and give you some bullshit advice and tell you I wasn't there and I don't know all the circumstances. And then you're not going to be happy. And then the first thing you said about you're happy about it, and you're going to leave, you'll not be happy because I didn't tell you what I wanted. And all you cops work together, and I knew you were going to tell me that because that's what the last cop told me. And all you cops are the same. And then they walk away mad because you didn't tell them what they wanted to hear. So guess what? As much as you don't want to deal with cops, cops don't want to deal with you. Rick, you can't say that. Not all cops that way. You're a bad guy. Shut up, you freaking crybabies. I swear. Nobody can be honest anymore. Everybody's got to lie to everybody, and people are like just loving these comfortable lies. Oh, give me comfortable lies because I can't deal with the hard truth. Well, then probably ain't the channel for you. All right. Send a message that suspect free to leave. Terminate the encounter. Suspect Phil, walk away. Biggest fiction. Other courts, however, understand. See, this is basically saying this court had it wrong, and these courts have it right. Other courts, however, understand that the free to terminate test is simply practical. Okay, it may be imperfect compromise between competing interests. Competing interests is the interests of citizens who want to be free and not assaulted by government, and the other competing interests of government wanting to get stats, prove that they're there to save you, and to arrest people, and to harass, collect taxes, and do their other shit. That's what the competing interest is. As the Fourth Circuit put it, if a suspect decided to walk away, it may have created an awkward situation, but awkwardness alone does not invoke the protections of the Fourth Amendment. Similarly, the Ninth Circuit observed that we must recognize that there is an element of psychological inducement when a representative of a police initiates conversation. I agree. Okay, I don't agree with the Ninth Circuit a lot, but on this case, I agree. When a cop contacts you, there is a psychological inducement that you kind of got to cooperate, or you should cooperate, or if you don't cooperate, there might be negative consequences, or you don't want to piss off the guy with the gun and the badge, because if you watch the news or watch cops lately, ain't no damn telling what'll set them off. They'll pull out a gun and put freaking 40 bullets in you and say I was in fear of my life, and it'll be justified. But I digress. But it is not the kind of psychological pressure that leads without more to an involuntary stop. So the courts are saying, hey, we know there's some involuntary pressure, but it's not enough. Well, who determines enough? The courts do. Engaging the suspect. The suspects or failure of attempt to contact a suspect often depends on the manner of which the officer was able to get the suspect to stop and talk to them. Okay, did I stop you by saying, yo, dude, you got a second? Yeah, man, what you need? Okay, we're good there. Yo, dude, you got a second? Fuck off. All pigs are cops and pigs. Fuck you, I'm leaving. Dude, man, why you got to be that way? Man, I'm trying to talk to you. Hey, I need to ask you a couple questions. Now, it's not so easy. Okay, this has become the unusual method of stopping a suspect. Constituting such an assertion of police authority of their will automatically result in seizure. Commands to stop. That's obviously detention. A command to stop, whether express or implied, will automatically result in the seizure if the suspect complied. What happens if the suspect doesn't comply? And this is actually a court case. You guys are going to be confused more. It isn't an unlawful seizure unless I seize you. If I try to unlawfully seize you and you get away and run, there was no unlawful seizure. There was an attempt, but there was no unlawful seizure. Rick, you're just playing with the law. That's not true. I know. I graduated the academy #1. All right, whatever. You freaking idiots. As the Court of Appeals explained, when an officer commands a citizen stop, this constitutes detention because the citizen is no longer free to leave. Examples of commands include, come over here. I want to talk to you. Sit on the curb. Step away from the car. Get off that bicycle. Lay down. Do the hokey pokey, put one foot forward. Step away from it. Okay? While a mere request, what's a request? Words have meanings, kind of like Bill Clinton. Well, what's the definition of sex? Well, what's the definition of it? What's the definition of is? What's the definition of a request? It'll matter. While a mere request to stop and talk will not result in detention, a command will be implied if the officer's words constituted a show of authority such that the suspect reasonably might believe he had to comply. Man, that's a whole lot of if, and, buts, and coconuts in that sentence. Really? A command will be implied if the officer's words constituted a show of authority such that the suspect reasonably might believe he had to comply. Holy shit. People go, man, why do you always say if, and, buts, and coconuts? Because that's a freaking law. All right, the suspect reasonably believed he had to comply. Then The encounter was transferred into detention. Who gets to decide if the suspect was reasonable? The courts do. Not the cop. Not the DA. The courts. They get to hear arguments. They get to look at totality of circumstances. And then they get to decide whether or not it was reasonable on what he believed. For example, U.S. versus Buckingham. A state trooper who had stopped to assist an occupant. Oh, Rick, that's CHP. He was assisting somebody. Those are good people. Those are good cops. They were out there to help. Of a disabled vehicle, suspected that they might be transporting drugs. Oh, so he stopped to help, but he suspected they might be transporting drugs. See? It's all about wording. If he had stopped them because he suspected them contacting, that might be a detention. But since he stopped them to assist and then suspected them, now we're okay. So he said, gentlemen, why don't you all come over here on the grass for a second, if you would, please. All right, is that a detention or not? That sounded pretty nice to me. That sounded like he was asking. Didn't sound like he was ordering. Although the trooper's words were phrased as a request, the court listened to the recording of the incident and concluded that his tone of voice was one of command. So his tone of voice changed an encounter, a contact, into detention. Rick, you can't. Who gets to say whether his tone of voice what he meant? The courts do. Well, that's not fair. So that's the courts. Change the law. I'm just telling you what the law is. You people, I swear to God, man, I could argue with people all day when they come here, especially cops that think they're just so freaking smart and want to come here and tell me about how brilliant they are with the law. And I'm like, dude, there's 1,000 ways I can trip your ass up with court, the way the court rules and what they think and what they might, if and but and coconut. And I can tear your ass apart if I'm a good defense attorney and make you think that you don't know what the hell you were doing. And again, this is 30 minutes, 32 minutes, and I just did the second page. So all the people that are like, man, the laws, yeah, I know the law, you don't know what you're talking about. And then all the people who are coming here, you know, on that one damn video where you can shoot a carjacker, they just killed me. Because I must have had 50 people give me the direct statute to where Florida says you can shoot a carjacker. And they all were like, I know the law, it says right here. And they're just quoting the law. And I'm just like shaking my head going, dude, if you shoot a guy because you read the law and said he could shoot a carjacker and that's the only reason you shot him, you're going to have issues. God damn it, Rick, I read you the law. That's what it says. You don't know what you're talking about. Okay, well, I just read 2 pages in an hour, and I didn't cover freaking probably 1/4, 1/8, 1/16, 1/42, 32.3754 pi of what the hell the law is out there in different states, different courts, different appeals, different Supreme Courts, state Supreme Courts, local, U.S. Supreme Court. I haven't covered shit in these 2 pages, and I talked for an hour giving you what if, and, buts, and coconuts. And then you people are going to come here and read me a law that says the law says I can shoot somebody carjacking, and that's the law, and I can do it, and I'm going to be okay. Okay, go out there and shoot carjackers all freaking day. Hell, you ought to just be driving around waiting for somebody to carjack so you can just shoot them in the back. Say, hey, man, the law says I can do it. Law says I can shoot bank robbers. I'm just going to run around and shoot people as soon as I see them run out of bank with a mask on. Be a lot of dead people around here lately. All right, look, I guess we'll go to part 3 for those that want to hang around.